We're going on the record on cause number DC 194895. We're here for a motion to strike. Counsel, make your appearances.
Alexandria Reisinger, present for plaintiff Eric Sains.
Greg Scott for the defendant.
Your Honor, plaintiff has moved to strike Dr. Levy for the second time in this case. Last time we were here, we had a motion to strike on the basis that after agreeing to tender Dr. Levy for deposition, that deposition notice was quashed and defendants were ordered to provide dates within 60 days. The date was provided, and once again, we received a quash for the subpoena ducis tecum that was attached. I outlined what those specific elements were for underneath the ducis tecum. They are very standard things. This is the exact same ducis tecum that was on the initial notice that was quashed, where we already had a hearing and they were ordered to provide dates. For that reason, we have moved to strike. As Dr. Levy has not provided any kind of inventory of what he, as part of his report of what he relied upon, all it says is medical records. He doesn't list out what things he relied upon. And he has refused to provide things like correspondence from the defendant, even though the first page of his report states questions posed and lists questions that look like they're drafted by the defense attorney that he's answering. So obviously there is some kind of communication going back and forth, but as of today, and this deposition is set for next Tuesday, he is not being required by subpoena to provide these documents. For that reason, as this is the second time we're playing this game, we're asking the court for relief to strike this expert since defendants refuse to provide the information they're required to under the rules.
Response?
Actually, it's not a game. It's the fourth time this young lawyer has tried to strike my experts. At the last hearing, you ordered me to produce him outside the discovery deadline, and of course, during this pandemic, and we have done so, Judge. I did not hire this expert. I hired a vendor who then hired Dr. Levy. He was originally hired as a pure consulting expert, and after I took his deposition of the plaintiff, then I decided to designate him, Dr. Levy that is, as a testifying expert. As I stated in the motion to quash, and then I've stated in writing, and I think I said it in earlier hearings, that the only documents that Dr. Levy has seen would be the medical records that they produced, meaning they want me to produce their medical records back to them. And that's a waste of time. Also, we've given Dr. Levy the transcript of the plaintiff's deposition. They have it, and that's a waste of time to produce that to them. Dr. Levy hasn't refused to produce anything. My guess is that Dr. Levy has never, for instance, even seen the invoice that was sent by the vendor for his work product. And I'll be willing to bet, judges, and you know how this goes, that he probably dictated the report and gave all the records and the whatever he dictated it on back to the vendor to prepare the final report. So he's probably never seen his final written report either. So in summary, Judge, this is a classic example of a young lawyer not realizing how insurance companies hire medical experts. And the only documents that he has reviewed were the documents that plaintiff counsel produced to me and I produced to Dr. Levy. There's then no other records that have been subpoenaed. And he does, obviously he doesn't keep electronic files or hard copies because the plaintiff is not his patient. And then of course we have the problem with HIPAA. So being ordered to produce something he doesn't have that plaintiff counsel already has possession of, I agree is sanctionable, but it's sanctionable for the plaintiff counsel's conduct. And if you, Judge, I will tell you,
I was reading the motion to strike, and maybe there's been so many of them. I don't see a copy of the subpoena ducis tecum attached to the motion to strike. Was it attached?
Yeah, it's attached to my motion to quash, Judge.
Oh, it's attached to your motion to quash. Okay.
Yeah, and what you'll look for is a second motion to quash that was filed on April 21st. And it's the exact same one that I had the first time when he wanted to take the deposition outside the discovery deadline period.
Your Honor, it also is Exhibit A to our motion to strike, page 8 of 12.
Let me see. What day did you file this motion to strike? I'm sorry, I'm looking at the wrong motion to strike. Let's see.
April 23rd.
And while you're looking for it, Judge, I did go to FedEx yesterday and personally copied all of the records that plaintiff counsel has given me that I forwarded to the vendor who forwarded to Dr. Levy. So, and of course, Dr. Levy doesn't want documents, hard copies from any stranger during the pandemic, but I'd be willing to drop off this packet that I personally copied at FedEx yesterday at plaintiff counsel's office, because there's no difference.
Let me just.
I might also add, I guess important too, Judge, is that when Dr. Levy got my packet for the deposition, there were still hundreds of pages that had not been produced by plaintiff counsel. And of course, that I can't ask questions about medical records that I haven't given. And so part of Dr. Levy's testimony next week will include the hundreds of pages that were belatedly produced well after plaintiff's deposition. Because, and for instance, like the MRI films that were finally produced by plaintiff counsel.
Your Honor, may I respond to that once you get the chance to review the Dukas Tecum?
Yeah, I'm looking at the Dukas Tecum now.
I think there's 5 categories, Judge.
So there's any and all medical records and bills pertaining to Eric Sainz, plaintiff in this lawsuit, any and all emails, correspondence with Greg Scott of the Scott Law Firm, any documents reflecting Dr. Levy's opinions regarding this case, including any reports, drafts, or notes, all documents, tangible things, reports, models, or data compilations, and all fee schedules and invoices provided to defendants in this case.
And what we said in our motion to quash is that for category number 1, Judge, we had about 200 pages of medical records at that time, at the time of the deposition, and that's what they gave us. And there are no text messages or emails between Dr. Levy and I, because we've never met. I've never talked to him on the phone. I'll talk to him for the first time 15 minutes before his deposition.
So, you know, I'm looking at that. And then did you ever provide any type of response to this Dukas Tecum? Or I guess what I'm kind of confused about here is why you moved to quash this. Did you quash the entire deposition or just the Dukas Tecum?
No, just the Dukas Tecum for the second time around. In fact, I said defendants will produce Dr. Levy for deposition at the agreed date and time, which is next week. What I quashed was subsections 1, 3, and 4, which require Dr. Levy to produce hundreds of pages of medical records that are already in plaintiff's counsel's possession.
That's a mischaracterization of the quash. The quash is for the entire Dukas Tecum, and then specifically says that the reason is why, because 1, 3, or those specific numbers. But the quash reads that for the entirety of those requests, there is no subpoena present as of today requiring Dr. Levy to provide those documents. So I want to make sure that's clear.
Okay.
Right. In normal situations, that at the time of the deposition, that's when the expert would produce the materials. For
Honor,
one thing.
May I take this opportunity to respond?
Sure.
Your Honor, I might be a young attorney, as Mr. Scott points out, but that means I understand agency principles and the rules of civil procedure very well. I know, as Mr. Scott is pointing out, he's trying to split hairs as to this vendor as a reason to hide the ball and play a game in terms of what he needs to produce and what documents should be provided by this expert. Additionally, the rules of civil procedure under disclosures as non-objectionable means I get these documents and I'm entitled to ask the expert with the subpoenas requiring him to provide these documents at his deposition. I get to see if he's had notes. I get to see what he has in his possession. I get to see what letters he's gotten from the agent of Mr. Scott in order to see what questions he was supposed to ask and what calculations he did, if any, when coming to his opinions. As of right now, I don't get to do that because he doesn't have to provide it because of Mr. Scott quashing this Ducas Tecum, which is not unreasonable. It's a 5-item, very basic Ducas Tecum. And instead of having these discussions about prior records where this was provided at a later time, etc., I should get to ask him when he got those medical records. And I can't right now because he's not required to go over those things with me. Additionally, Your Honor, I'll go into the issues with the films. We submitted these things to opposing counsel as soon as we got them. We submitted them 3 times, but the envelope questionably was torn up, and we got communication that was not received. So we kept sending it, and then we had to send a Dropbox. So these issues are tangential at best, but I want to make sure that the record is clear.
Yeah. So the bottom line, Judge, is that all of the medical records he reviewed are in plaintiff's counsel's possession. There are no notes. There's no electronic file. There's no hard copy because the plaintiff is not Dr. Levy's patient. He just was at first a pure consulting expert. Then I took the plaintiff's deposition and learned that the plaintiff had been receiving ongoing shoulder pain treatment for years leading up to our accident. And that's when I decided to send the new packet with all of the records that I had at the time, plus the deposition transcript, to Dr. Levy. And that's all he has. And that's the same documents that plaintiff counsel has.
You can't have it both ways where you're saying you've never spoken to the man, but you somehow have all this knowledge about what he has and doesn't have. Either you've never spoken.
No, because I gave it to the
Hey, don't yell at each other. Just address me. So this is my thought on this, Mr. Scott and Ms. Reisinger, is that I don't think the subpoena Ducas Tecum is unreasonable. He should have some type of invoices, even if he has to get it from his company that he's working through. I mean, we've seen these. I've seen this hundreds of times before. You know, she's going to be able to ask him how much do you charge. You should.
And we got those yesterday, Judge.
Okay, so I'm going to the extent that it's set today, I'm going to overrule the motion to quash. You need to respond. You can just say on the medical records, hey, look, he's only relied on the medical records provided by the plaintiff and no others, because in a lot of these depositions or a lot of these cases, the expert may have reviewed other medical records, and we just need to make that clear on the record. That's all he's reviewed. So when you respond to the Ducas Tecum, say this is we've only relied on what's given to us by the plaintiff and nothing else.
I'll do that in letter form today, Judge. I guess that's how you want me to handle it?
Yeah, handle in letter form today with the invoices and responding to the rest of the stuff. And then the deposition is scheduled for Tuesday. Is that right?
That's correct.
Next week sometime.
Yeah, whenever it's set, it's ordered to go forward. And if defendant doesn't comply with this, then the expert will be struck. All right, anything else, guys?
Well, I guess because of the pandemic, there's some logistical problems. So this is going to be taken like Zoom.
Sure.
And I've never taken a deposition by Zoom, but it seems to me that plaintiff counsel is going to be at her office. I'm going to be at my office, and Dr. Levy is going to be at his office, and the court reporter, I don't know where she'll be. So I don't exactly know how Dr. Levy's going to produce hard copies of anything during his deposition, during a Zoom event.
So there's been a number of seminars on this, Mr. Scott, about how to deal with that. There's a share screen. What most people are doing in these situations are using the share screen function. And then, of course, under the standing order, you have a requirement to provide all parties a copy of the whatever documents are going to be used. So you just need to email or Dropbox Ms. Reisinger any documents that are responsive to the subpoena. And if there's a document that you probably want to share each other's emails in advance or Dropboxes, if there's something else that the doctor is going to rely upon that needs to be produced, that will need to be produced electronically.
Judge, like really don't have any computer skills. I've already made the copy of everything at FedEx. If it's okay with you, I just like to drop this off at her office with the cover letter that you've ordered today, because I've already made the copies, and I don't know how. I wouldn't know what a Dropbox was if it fell on my head.
Ms. Reisinger, what do you think of that?
That's fine. I can accommodate, but I'll need to coordinate. I don't live far from my office, but I'm still working remote. So I just need the time and a place, and I will be there. So.
Well, you don't need to be there. At the law firm.
Yeah, just drop it off at the law firm. You two don't need to meet. And also make sure you email the letter, maybe not all the attachments, but the letter that's responsive. Make sure you email that to Ms. Reisinger by the end of the day.
I'll do that, Judge.
Okay, guys, good luck with the deposition. And if there's any issues, feel free to reach out. But I expect this deposition to go forward as planned.
Thank you, Your Honor.
All right, guys, have a great day.
Have a good weekend.
All right, bye-bye. Mr. Meredith, are you there? And wait, before you leave, Mr. Scott, Ms. Reisinger, is Mr. Meredith involved in your case or not?
No, Judge.
So he's involved in the other case. So, all right, so you guys are excused. He doesn't have a.
So we're signing off, Judge?
Yes.
You're welcome to sign off if you want to. Mr. Meredith, are you there? You don't have any. Mr. Meredith, you're okay. There you are. Unmute. Can you hear me, Mr. Meredith? Mr. Meredith, are you there? Okay, I unmuted you, Mr. Meredith. Are you there? Mr. Meredith, are you there? All right, I'm going to turn off the YouTube, I guess. I don't, he seems not to be there because he's unmuted.